My name is Joost Pauwelynn. I'm a professor of international law here at the Graduate Institute of International and Development Studies in Geneva. I'm also the head of the International Law Department here and the co-director of the Institute's Center for Trade and Economic Integration. And one of my other occupations, pastimes, is I'm one of the 10 arbitrators on the MPIA. So the MPIA is an abbreviation for Multi-Party Interim Appeal Arbitration Arrangement. It's a mouthful, but it's essentially a procedure that allows for WTO disputes to move to an appellate stage. And it's a procedure, an arbitration procedure provided for under the original WTO treaty, Article 25 of the Dispute Settlement Understanding. So the MPIA was created in April 2020 because there'd been a blockage on the appointment of appellate body members, which in December 2019 led to the appellate body becoming dysfunctional. So to avoid that disputes, when brought to the WTO, could be blocked by appealing, a subset of WTO members created the MPIA to look into WTO disputes at the appellate stage. But it is very importantly an interim arrangement. So the MPIA is only there for as long as there's not a sufficient amount of appellate body members in place. And when there's again sufficient number of appellate body members, the MPIA will disappear. So think of an MPIA dispute in terms of 4 stages. The first stage is exactly the same as under regular WTO dispute settlement. So you have consultations, you then have a panel looking into the case all the way up to its final report. So that's stage 1. Stage 2 is when either party wants to appeal. What happens then is the panel will not circulate its final report. Instead, it will suspend the panel proceedings. So panel suspension is step number 2. Step number 3 is the MPIA, or 3 MPIA arbitrators, randomly selected, looking into an appeal. It could be a cross appeal, submissions will be exchanged, hearings will be held. That is step 3. Step 4 is the MPIA award. The Appellate Arbitration Award will be issued, and it will include the panel report to the extent panel report findings are not reversed. That report doesn't need to be adopted by the dispute settlement body. Its mere issuance makes it binding on the disputing parties. And very importantly, this MPIA arbitration report will be implemented subject to the regular compliance procedures, including suspension of concessions in the phase of non-compliance, the exact same procedures as would have applied to a panel or appellate body report. So it's important to the system because for disputes between WTO members that have signed on to the MPIA, the dispute can run its regular course. So appeals can be looked at and no blockage can occur. So imagine a dispute between China and Australia, both participants to the MPIA. A regular procedure can be filed, a panel report can be issued, an appeal can be lodged, and such an appeal wouldn't block the procedure. The MPIA would be there to hear it. Now, if on the other hand, you're a trader from the UK or the United States, the UK and the US are not parties to the MPIA. If disputes at the WTO involve such non-parties, there is an option to appeal, but such appeal will be before an appellate body that is no longer there. So that will block the process. So in essence, it means that as between parties, WTO members that haven't signed on to the MPIA, the WTO dispute settlement system no longer functions as it was supposed to. So for traders, interest groups from countries not party to the MPIA, this can be a real problem. Now, for those who come from MPIA participants, this stopgap solution allows for WTO dispute settlement to function. So the MPIA is an interim solution, and it has only been adopted by a subset of WTO members. So in that sense, you could think of it as a plurilateral mechanism. It's a multi-party arrangement, but not all WTO members have signed on to it. Actually, as we speak, there's 52 WTO members who are participants to the MPIA, and I'm counting now the EU as 27 EU member states, and the EU as a separate WTO member. So in that sense, it can be looked upon as a plurilateral. On the other hand, what is really important is that it's not a plurilateral in a different sense, because the MPIA mechanism operates under the multilateral WTO treaty. It's actually arbitration as explicitly provided for in the original WTO treaty, Article 25 of the Dispute Settlement Understanding. So in that sense, it operates under the umbrella of the multilateral WTO and will be supported if cases come up by the WTO Secretariat, the multilateral WTO setting.